Well, hello and welcome back to my channel. If you haven't already heard, I've been hit with the lovely little bug that has occurred. I had been testing negative on rat tests and I decided that I would just go and get a PCR and and then I got ridiculed for going. And anyway, everyone around me was testing positive, and I thought, well, no, that something's up. So I've actually just woken up. So if I look like I'm half asleep, it is 12:17 p.m. on Wednesday, and I've just woken up and discovered that there were some new filings. So we're going to go through that. Plus, we want to look at some stuff because there's been some revelations today. The inquiry into the Barilaro appointment to the US has started today, and there have been already some really interesting revelations that have come out of that. And it's going to be very, very interesting. So let's first of all start with, oh, great, I just closed the window. I'm really not with it. All right, so let's have a look. Oh, look, we've got the spam here, so that's okay. I've got my finger to the on the buzzer. So we will deal with him, whoever it is. So we will get there. So I've got the proposed order, I've got the memorandum in support, and I've just got to open up it's a big document. So they're big documents. So we'll see what happens. So I'm just blocking the user at the moment. Hello, Dang. How are you? Oh, look, back again. Been testing like positive on rats, but negative. Yeah, well, as I said, I've been testing negative, and it's just that when everybody else around me's got COVID and I'm still testing negative, I'm just going to go for peace of mind. But so I'm just looking at which is the best way to start. So let's have a look. Let's start with this one. I think this one looks all right. Oh, gee whiz, we've got some big stuff here to look at. Some motion to compel proposed orders. All right, we'll start with the order. So they're proposing, they filed a motion for Katie Joy to be compelled. So it's a proposed order, and what you'll see here is it says proposed order. So I know people get a little bit excited and go, this has been granted. On this one, as you can see, it clearly states proposed order. Okay, so definitely it is a proposed order. And that's really important to remember. This is just proposed. This is what they want the judge to sign off on, okay? They want the judge to sign off on this. So hello Grant, the above mentioned matter was before a sign mentioned on the 20th of July. This is what they want on the 20th of July. Compel discovery. So they want her to be made to do discovery. That the motion to compel is granted. Defendants must supplement their response to plaintiff's integrity number 3 within 14 days. Defendants must produce all documents, and that plaintiff's motion for an award of costs and fees be granted, and that the plaintiff, aka Katie Joy, be made to pay the costs. Okay, that's what they're asking for. That is what they're asking the judge for. So now we've got 2 more here. Here's the memorandum of law in support of the motion to compel. So they filed the motion. All right. This is their. So they've done 2 documents here. They've got their memorandum in law, and then they've got an affidavit in support of it. Okay, and for those of you that are coming for the Barilaro stuff, we will be dealing with that after we've dealt with this. It is worth the wait. Trust me, it is worth the wait. I was absolutely gobsmacked when I've seen what I've found today. And if you follow Friendly Geordies, he's already alluded to it. Yeah. There's questions. I have questions. All right. So it says defendants Catherine Mansky Paulson and Without a Crystal Ball LLC have spent the past several years spreading defamatory lies against plaintiff Michael Todd Chrisley. These include the false allegation that Mr. Chrisley attempted to extort his own daughter with the threat of releasing a sex tape featuring her and a man other than her then husband. In one of those defamatory videos at issue in this case, Miss Paulson improperly claimed that an individual with an intimate personal knowledge of Mr. Chrisley and his family, an anonymous crew member from Mr. Chrisley's reality TV show Chrisley Knows Best, placed an unsolicited call to Miss Paulson and stated that he or she believed this allegation based on his or her observations. Now, let me just pause there. For those of you that have been following Katie Joy, you would know that we have all heard this. There's some anonymous source, and she's referred to a crew member. She is referred to this, okay? So now, it appears likely that Miss Paulson either fabricated this call or simply parroted the defamatory words of an anonymous caller who was not a Chrisley Knows Best crew member. Mr. Chrisley alleges as much in his complaint and has served an interrogatory seeking to confirm that allegation. So I think what they're saying is that he's wanting to know who the source is. But defendants have stonewalled Mr. Chrisley's efforts to take discovery on this topic, contending that information concerning the call is privileged under the Minnesota Free Flow of Information Act. The Act includes an exemption for defamation claims like those at issue here, and thus does not apply. Accordingly, Mr. Chrisley moves the court for an order compelling Miss Paulson to supplement her interrogatory response. Under the footnote, pursuant to Minnesota Rule of Civil Procedure, plaintiff certifies that he made good faith efforts to confer with defendant to obtain the requested relief by twice requesting defence's counsel availability to meet and confer regarding this motion without receiving a response. See affidavit of Charlie Gohi. So they're stating that they have tried on 2 occasions to speak to Paulson's lawyer to sort this out, and nothing's happened. So now they're taking this action. Now, doesn't Katie Joy goes, well, their lawyer can ring my lawyer and we'll sort it out. Well, according to this, that they've sought for 2. They've sought 2 on 2 occasions to meet with them, and they've not responded. All right. This is what Chrisley's lawyers are saying. Moreover, more than 6 months after responding to Mr. Chrisley's document requests, defendants have only produced a small handful of documents, many of which are not clearly responsive. Whole categories of vitally important documents remain outstanding. Despite assurances that additional documents are forthcoming, defendants have yet to make any further productions, even as more than half of the period of discovery has passed. Remember, they put forward a joint discovery. If you remember that, they put to the court their discovery, so apparently that's not been, this is what they're saying. They're not following that either. Oh, hello, Terry. Hello, LER. Hello, everybody that's joining me. I've still got sorry, we've still got this person here. Oops, didn't mean to do that. I meant to block them. Why isn't Ralph doing his job? Why isn't Ralph doing his job? I need to sack Ralph, don't I? I need to sack him. Hello, Dom. Oh, Doom, you're here now. You can get rid of all the naked Tinder people. I've got a. So anyway, Dom's one of my mods. So Dom, when you say give it to me, Dom, do you want the naked Tinder person? Sorry, I had to say that. Sorry, Dom. But I knew you'd find that funny. Right. Let's get back to this. All right. All right. So it says accordingly, Mr. Chrisley has no recourse but to request the court order defendants to complete their production in response to plaintiff's existing discovery requests by a date certain no later than the 3rd of August 2022. All right. See, I knew Dom would find it, would get it. So, yeah. To the naked Tinder people, you can go visit Just Doom. Anyway, right. So let's get back to this. We're serious now, right? We're serious. For those of you that just joining me, I've got the little bug that's going around. I've got COVID, so I came through confirmation today. So I've got a headache. I've got a really bad headache, and I'm suffering from nausea. That's the only symptoms I've got, really. So anyway, just all right. So here's our background. Okay, Miss Paulson and her company defamed the plaintiff. Plaintiff Michael Todd Chrisley is a real estate investor and star of USA Network's reality program. So sorry, just before we go on, you're just joining us. Chrisley has just filed a motion, or is filing a motion to compel discovery, because there has been some stuff that's not done, and it would seem like he wants to know who it is, who is KJ's source, that her anonymous source from Chrisley knows best. His best bet is that there's not a source, but if there is a source, he wants to know who it is. It's very familiar to the whole Tardy thing, you know. She may just give up her source to get rid of the lawsuit. You know that, don't you? Are you aware of that? We know what she does. If they put the pressure on her hard enough, she'll just roll over and give them the source that gives them. She will just give them the source they want, because we know that that's what she does. But anyway, what Tinder people, says Grant. Yeah, we had a little bot in. Okay, so the program follows Mr. Chrisley and his family. Defendant Catherine Maskey Paulson is an internet personality and blogger producing content with a focus on reality television. Through her company, Defendant Without a Crystal Ball, she monetizes her social media presence on YouTube, Twitter, Instagram, Facebook. Miss Paulson publicly claims to be a close friend of Mr. Chrisley's daughter, Lindsay. In fact, I think Crystal Bill showed some of that the other couple of nights ago. Some of the posts that Katie Joy had, not Crystal, Cactus Bill, had posted about Lindsay. So if you want to get some more information on that, I would recommend checking out Cactus Bill and her Lindsay Chrisley video, because she's covered that quite well. Where she's put posts about Katie Joy, talking about how she's great friends with Lindsay. So, all right. who appeared on Chrisley Know Best for several seasons until the network just declined her to include her in the future seasons of the program. At that point, Lindsay Chrisley became estranged from her father and the rest of the family and lashed out at them in the media. As relevant to this motion, Lindsay Chrisley appeared on the daytime talk show Dr. Phil on the 17th of October 2019. She recounted a meeting with Mr. Chrisley, during which Mr. Chrisley allegedly told her that Chase Chrisley, her half-brother, had obtained a sex tape featuring her and a man other than her then husband for $5,000. Lindsay Chrisley agreed when asked by Dr. Phil that she viewed this as a veiled threat related to her cooperation with law enforcement in its investigations of Mr. Chrisley and the rest of her family. The account of the meeting was inaccurate and there was no such threat. Plan to Create says she doesn't know their name, who they are, just blindly using an anonymous source or made it up. Well, I think that's what they're alluding to, is that if she doesn't have a source, she's made it up, and therefore, I mean, that's quite bad. We know that, you know, journalists can't do that. So we know that, okay? Miss Paulson spent 2 years following this interview spreading, embroidering, and expanding upon the defamatory falsehood that Mr. Chrisley attempted to extort his daughter by threatening to release a sex tape featuring her if she refused to lie to authorities investigating the Chrisley family. In particular, 2 days after Lindsay Chrisley appeared on Dr. Phil, Miss Paulson published a YouTube video falsely claiming that somebody anonymously from Chrisley Know Best crew actually reached out to me to let me know they watched Lindsay Chrisley's interview on Dr. Phil, and they said, I believe her. I'm not even lying. I love it when she says, I'm not even lying, because we all know, we all go, yep, right. Mr. Chrisley alleges that Miss Paulson never received a call from a Chrisley Knows Best crew member and that Miss Paulson fabricated the call in order to bolster her credibility of the false allegations. Indeed, Miss Paulson eventually removed this video from her YouTube channel in a tactic acknowledging its falsity. So that's the background. So now we're into defendants have not complied with their discovery obligations. So this is part B. Mr. Chrisley first filed his first set of interrogatories and requests for production on the 10th of December 2021. So we've got the affidavit here. Interrogatory number 3 requests that Ms. Paulson identify any of the Chrisley Knows Best television production crew with whom you've communicated, including the nature, substance, and date of the communication. Defendants missed the deadline to respond, and when questioned, stated they did not believe discovery should proceed in this case until the court ruled on their motion to dismiss. And it says, defendants later requested to postpone the hearing on their motion to dismiss and ultimately withdrew the motion the day before oral argument. Do you remember that? So the day before it was all supposed to go to court, she withdrew it. So plaintiff then explained that there was no stay of discovery in this case and demanded the defendants comply with their discovery obligations. 1 week after deadline, defendants served their discovery responses. And we know that courts don't like it if you don't obey timelines. This is Australia. One of the quickest ways to upset a judge, particularly in Australia, is to not comply to deadlines. They hate it. They hate it with a passion. So, if you want how to upset a judge, ignore deadlines or continually ask for extensions, and that will really annoy them. I don't know what it's like over in the US, but if the judge is in the US or anything like Australia, you don't want to upset a judge by messing around with deadlines. They hate it. They hate it with a passion. Around the same time, defendants produced approximately 60 files to plaintiff, 5 videos, 35 pictures, 7 screen captures, and 3 documents. Many of these documents are not clearly responsive to any of Mr. Chrisley's discovery requests, and all or nearly are all publicly available materials. Then on January 28, 2022, defendants produced a spreadsheet of Ms. Paulson's responsive tweets concerning Mr. Chrisley and promised that additional discovery production would be forthcoming as its review is completed. Defendants have not produced a single document since then. At this point, the defendants have not produced any documents responsive to the majority of Mr. Chrisley's documents. So now we've got another footnote. The requests as to which Ms. Paulson has completely failed to provide responsive documents include RFP number 2, communications Ms. Paulson had regarding or referring to Mr. Chrisley. Number 3, notes, drafts, journals, or other documents related or referring to Mr. Chrisley. Number 6, documents sufficient to show engagement with Ms. Paulson's social media posts regarding and concerning Mr. Chrisley. Number 7, documents sufficient to show compensation derived from Ms. Paulson's social media activity. They want to know how much money she's earned from her social media posts. Number 8, documents sufficient to show without a crystal ball corporate structure and organization. They want to find out who the we are, I guess. Who's the we of without a crystal ball? Documents sufficient to show income derived by without a crystal ball. They want to find out how much money she's got. All right. Defendants have refused to answer interrogatory number 3, stating objection calls for information protected by the journalist's privilege outlined in Minnesota statute, Cervantes versus Times. Subject to that objections, defendants never received the name of the person with whom they were in contact. That's their defense. So in affidavit exhibit B is there. This frustrated Mr. Chrisley's efforts to obtain the discovery necessary to demonstrate that Miss Paulson did not receive the claimed call from a member of Chrisley's Knows Best's crew. In particular, the response did not include any information about the circumstances or substance of the call or any detail as to Miss Paulson's effort to confirm the individual with whom she spoke to was in fact a member of Chrisley's Knows Best. So they want to know, essentially, what steps did she take to verify that this person was from Chrisley's Knows Best? How did she know that this was a person from the crew? And then they want to know why she didn't take their name. If you're talking to somebody and you're trying to verify, remember she said she verifies everything. Well, their argument is that she would have had to have verified it. Anyway. Mr. Chrisley's counsel wrote and explained that with respect to interrogatory number 3, the privileged defendants invoked does not apply and requested the defendants supplement their responses. So again, we're going to see a lot of this in the affidavit when we look at it. Defendants refused. See, got here affidavit exhibit D. There's something like 45 pages or something to this affidavit from the lawyer. Mr. Chrisley's counsel responded by email and requested to meet and confer. In this email, Mr. Chrisley's counsel also requested the defendants advise as to the status of Miss Paulson's outstanding document production and warned that if other responsive documents were not forthcoming within the reasonable time, plaintiff reserved the right to raise the issue in his motion to compel. Miss Paulson's counsel did not reply. So they've actually ignored. So from what Chrisley's saying is that essentially Paulson's lawyers have ignored everything. So they're doing a motion to compel now to get action. And this again goes against everything that she says about the fact that because he's under house arrest, that he couldn't do anything. Right? Because she obviously thought that she could, they didn't have to do anything. I mean, that's really foolish. This lawsuit's not going anywhere. All right. Mr. Chrisley now brings the motion to compel and respectfully submits that defendants must be ordered to complete their document production and submit the interrogatory responses. So he wants the court to make them to compel. Right, so now we've got the argument. Defendants must be compelled to complete their document production. Plaintiff and served his discovery requests in December 2021. To this date, remember, she can easily be beat. Well, that's right. There'll be somebody to blame. Defendants have produced less than 60 documents, most of which are publicly available. Moreover, many of the documents are not clearly responsive to the plaintiff's discovery requests. For example, defendants produced screenshots of news articles concerning Mr. Chrisley that were not written by Mr. Paulson and which contained subject matter unrelated to this litigation. Oh no, really? I shouldn't laugh. I'm sorry. That's very unprofessional to me. That's very unprofessional of me. You've got to give them what's relevant to the case. Even myself as a learner lawyer knows that. You can't. They're trying to deflect, aren't they? They're trying to say, well, everyone else is reporting, is saying this. It's everybody else but me. That's the impression that I'm getting anyway. Defendants have not produced any additional documents in roughly 5 months, despite assurances that they would do so. And defendants have not produced any documents responsive to 6 of the 10 RFBs served by the plaintiff. Essentially, every request specifically requiring Ms. Paulson to provide non-public information. In short, defendants have deprived Mr. Chrisley of critical discovery on everything from communications Ms. Paulson had regarding the subject matter of this lawsuit. To documents to sufficient to show Ms. Paulson's ill-gotten revenue from the campaign of defamation. The goal of discovery is to encourage the exchange of relevant information by the parties prior to trial and to discourage and prevent unjust surprise and prejudice at trial. From Gale versus County of Hennepin. Defendants will thwart that goal if the court does not require them to timely comply with their long overdue discovery obligations. Accordingly, plaintiff is left with no alternative but to move the court to compel production of the requested documents not later than August 3, 2022, at which point plaintiff would have roughly 3 months remaining to conduct fact discovery. Remember, they've amended the discovery timeline and everything. All of that was agreed to. So her lawyers agreed to all of this, and now they're trying to change the goalposts. So it's in my opinion, it's very tacky, very tacky. Defendant's response to interrogatory number 3 is deficient and must be amended. An evasive or incomplete disclosure, answer, or response is to be treated as a failure to disclose or respond. That's from the Minnesota rules. Ms. Paulson provided an incomplete answer to plaintiff's interrogatory number 3 and refuses to supplement her response. Plaintiff thus moves this court to exercise its broad discretionary power and grant an order compelling defendant to supplement her answer to interrogatory number 3. American social structures are not compatible with the rigid singular rule of law. Chaos follows to fill the gaps. White collar crime, sorry, it's a crusade. Yeah, of course it is. It is. But, you know, and don't forget, Chrisley at the moment's got deep pockets, so he can, you know, he's able to use the law to you know, his advantage. All right. Ms. Paulson cannot rely on the Minnesota Free Flow of Information Act to excuse her failure to answer the interrogatory. As an initial matter, to the extent Ms. Paulson fabricated the interview, the law does not apply at all. The Act pertains to disclosure of the person or means from or through which information was obtained. It does not shield the intervention of information not obtained from another source. Wow! So they're saying she can't be protected because she made it all up. Well, hey, that's why. Sorry, they're saying unless she shows them some proof, she needs to show that she did get the information properly, or else she's not. If she wants to use that protection, she has to prove that she has a source. Really, otherwise she can't use the protection. They're really calling her hand here. That's what they're doing. They're really making her play her hand. Regardless, the Act includes an exception that applies in cases alleging defamation such as this one. This exception requires disclosure of an anonymous source when the person seeking disclosure can demonstrate the identity of the source will lead to relevant evidence on the issue of actual malice. The party seeking disclosure must show that there is probable cause to believe that the source has information clearly relevant to the issue of defamation, and that the information cannot be obtained by any alternate means or remedy less destructive of First Amendment rights. In short, the defamation exception applies when a plaintiff can demonstrate that the identity of the source will lead to evidence having any tendency to prove or disprove that the defendant spoke with the knowledge that the statements were false or with reckless disregard as to whether the statements were false or not. The plaintiff need not prove that the declarant indeed spoke with actual malice before the exception can be applied, but only need to establish that the identity of the source will lead to relevant evidence on the issue of actual malice. Yeah, they're essentially they're essentially putting her into a corner. If she wants to show that she didn't, whether or not the statements have malice or not, doesn't, yeah. So she only needs to prove that there is a source. Information sought through interrogatory number 3 bears squarely on Ms. Paulson's actual malice. In particular, a statement may have been made with actual malice if it is fabricated by the defendant, is the product of his imagination, is based wholly on an unverified anonymous telephone call, or if the publisher's allegations are so inherently probable that only a reckless man would have put them into circulation. Now, that's a quote from a lawsuit. So their allegation is that she's fabricated the source, and therefore she's got no protection. Accordingly, whether Ms. Paulson fabricated this interview or reported based on the wholly unverified anonymous phone call, Ms. Paulson knew her statements to be false or acted recklessly in making them. The exception also requires probable cause to believe that the source has information clearly relevant to the issue of defamation, and that the information cannot be obtained by any alternate means. Here, there is probable cause to believe that there is no source, or the source was not who they claim to be, and Ms. Paulson simply parroted the false allegation of the anonymous caller. This information is clearly relevant to the issue of defamation. When the identity of the speaker is hidden under a cloak of anonymity, it's self-evident that the identity of the speaker will lead to relevant evidence on the issue of actual malice. Secondly, Mr. Chrisley has no alternate means to obtain this information because Ms. Paulson is the only identifiable person with the knowledge of that phone call and the individual who allegedly placed it. Indeed, if Ms. Paulson's claims regarding the anonymous Chrisley Knows Best crew member are false, there is no other existing source of information besides the person who fabricated the interview. In sum, the identity of the anonymous caller is relevant because it tends to show that Ms. Paulson either spoke with knowledge that her allegations were false or acted recklessly. 2, there is probable cause to believe that disclosure will lead to information relevant to the issue of defamation. And 3, there are no alternate means by which Mr. Chrisley can obtain this information. Accordingly, the defamation exception to the Free Flow of Information Act applies, and the Act does not excuse Ms. Paulson's failure to answer interrogatory number 3. She's going to have to either state that she's got a source and reveal some information about that source, or she's going to have to state that she lied. She's been painted into a corner here. Ms. Paulson's contrary arguments advanced through the conferral process do not bear scrutiny. First, Ms. Paulson has argued, I believe her, is a non-actionable statement of opinion. But the defamatory statement issue is not Ms. Paulson stating, I believe her. Rather, the defamatory statement is that Ms. Paulson's false claim that a crew member of Chrisley's Knows Best, who had intimate knowledge of Mr. Chrisley and his family, said, I believe her, with respect to Lindsay Chrisley's allegations about her father, and that this individual provided supporting details. If there is no such individual, or if the individual was not a member of Chrisley Knows Best, Miss Paulson's claim that an individual with non-public knowledge supports Lindsay Chrisley's allegations is false and defamatory. Wow. Moreover, there is no wholesale defamation exemption for anything that might be labelled opinion, because if the speaker says, in my opinion, John Jones is a liar, he implies a knowledge of facts which led to the conclusion that Jones told an untruth. Mirkovich versus Lorien. Such is the case here. Miss Paulson's claim that an individual who has intimate knowledge of Mr. Chrisley and his family supports Miss Chrisley's allegations not only falsely points to the existence of such an individual, but falsely implies the individual's knowledge of relevant facts regarding Mr. Chrisley's behaviour and character. Miss Paulson has also argued that a ruling of falsity of her statements is necessary before Mr. Chrisley may seek discovery into whether Miss Paulson spoke with actual malice. The plain language of the Act makes clear that the defamation exception applies, and the information is discoverable where the disclosure will lead to relevant evidence on the issue of actual malice. Minnesota statute Weinberger, which states out the applicable analysis, does not require court to determine allegations to be false before obtaining discovery. So there's a footnote here. So Terry C says, I think this lawsuit will catch her lying like a deer staring into headlights. We may have another source exposed, maybe. So the footnote says, Miss Paulson's argument apparently relies on Boa versus Gannett. In that case, the Court of Appeals combined requirements expressed in Minnesota statute with requirements used by other courts in jurisdictions without a similar statute codifying the protections authorized for reporters in civil actions. This analysis entailed a 5-factor test, including whether the plaintiff had made a prima facie showing that the allegedly defamatory statements are false. The Minnesota Supreme Court expressly overturned Boa in Weinberger. To the extent the analysis in Boa is inconsistent with this opinion, it's to be overruled. All right. Indeed, the truth or falsity of a statement is inherently within the province of the jury. See Lewis versus Equitable Assurance. Miss Paulson may not place Mr. Chrisley in the untenable position of being required to prove the falsity of her statements before he can obtain the discovery necessary to do so. Miss Paulson has similarly argued that her statements at issue in this case are not defamatory because they truthfully relay allegations against Mr. Chrisley made by his daughter. Setting aside Miss Paulson's own unique embellishments on those allegations, not the least of which is her claim that an unnamed Chrisley Know Best crew member supports Miss Chrisley's story, this is incorrect as a matter of law. Under common law, republication rule, one who repeats or otherwise republishes defamatory matter is subject to liability as if he had originally published it. Restatement of torts. Hang on, just bear with me for a minute. Sorry, my daughter's just come home. She's spent a couple of nights in her new place, and anyway, she's got her weekend at the moment, so she's come to move some of her stuff out because I can't see her because I've got COVID. All right. So explaining that the republication rule provides the speaker who knows or should know the statement is false and defamatory but repeats it nonetheless is equally liable for the defamation of the original speaker. The fact that it is verifiable, Lindsay Chrisley made some of the allegations at issue in the first instance is no way relieves Miss Paulson from liability for repeating them or publishing her own variations on them. and it is beyond serious dispute that allegations and issues here are defamatory or false. Terry C says, I must say this document is well written, not a copy and paste. Yeah. And this was what Google got in trouble with Barilaro. It was the republication, having it on their platform. So, if you then repeat something that you're not sure if it's true or not, without verify, you can be, republicational. Because the thing that I'm about to share with you about Barilaro is actually from, I'm sharing from the Labor opposition, who is keeping a close eye on the investigation. Anyway, but yeah, so they're saying there that even if Lindsay Chrisley had said it, repeating it is just as bad as what was originally said. Even if Lindsay Chrisley said it, it still doesn't matter. You are still liable for repeating that stuff without verifying it. Okay? And again, it's the way that it's said. If you say, Lindsay Chrisley alleged XYZ, that's different than saying, well, Lindsay Chrisley said this about her dad. Or, you know the way she does it. All right? Finally, Ms. Possum may raise Cervantes versus time. In Cervantes, the Eighth Court articulated a test for determining when a defendant journalist may invoke a constitutional privilege to avoid disclosing confidential sources in a libel suit. But in the Minnesota Supreme Court has not recognized the First Amendment journalist's privilege and has never adopted the standards set forth in Cervantes. In Unprofessional Conduct 720, in fact, Minnesota Supreme Court has noted long-standing disagreement Cervantes' reasoning. Rather than rely on judicial adoption of the Cervantes standard, the Minnesota legislature enacted the Free Flow of Information Act, which provides the sole source of protection for journalists. In Minnesota, courts seeking to shield their sources. Even if Minnesota adopted Cervantes' standard, the outcome of this motion would be unchanged because Mr. Chrisley made a concrete demonstration that the identity of Paulson's news source would lead to persuasive evidence on the issue of malice. So it would seem that Minnesota is happy to protect under Minnesota law, she can protect the name of her source if she has a source. So, okay, so the court must award plaintiff his attorney fees and costs. So, Chrisley's asking for the fees to be paid. Under Minnesota Rule of Civil Procedure 37, the district court shall award the attorney's fees if a party fails to provide answers to interrogatory or fails to provide documents requested as part of discovery. Minnesota Civil Procedure stating that the district court shall require the party whose conduct necessitated the motion to pay the reasonable expenses incurred in making the motion, including attorney fees, unless the motion was filed without a good faith effort to obtain discovery without court action. Apologies, the document says don't repeat gossip. To some extent, Grant. So you can. It's not about whether you repeat gossip or not. It's how you repeat the gossip. So if you go, Lindsay Chrisley did an interview on Dr. Phil today, and she made some allegations about her father, and this is what she says. It's all about, as we heard in the, as the Chief Justice of the ACT said, about Lisa Wilkinson's speech and why the Brittany Higgins trial was delayed, or the accused trial has been delayed, it was all over this word allegedly. It's about the fact that you can't already talk about an outcome of something that has not occurred, that are only allegations. I can say whatever, yeah, I do. I could say whatever I liked about anybody, but unless I can prove that it's a statement of fact, then it's only allegations. So And that's what got Friendly Geordies in trouble. You know, he didn't say that Barilaro was allegedly a corrupt conman. He said he was a corrupt conman, although he would argue that he had stuff to back up and he couldn't defend it because it was under parliamentary privilege. But it's about how it's reported. So you can repeat it if you are very careful in your repeating of it. Because let's face it, a lot of news stories, particularly the Hollywood stuff, is gossip. A lot of the entertainment stuff is just gossip, but it's the way it's done. So so essentially, because they said at the start that they had made 2 attempts, or they had made attempts to contact Paulson's attorney to sort this out, and they hadn't. They've said that they've used good faith. So because they've got to bring this motion, Paulson has to pay. Here, an award of attorney's fees and costs is warranted because defendants have persisted in baseless objections, improperly attempted to use a motion to dismiss, to forestall their discovery obligations, and largely failed to participate in discovery. For these reasons, Mr. Chrisley respectfully requests that the court grant his motion to compel and require defendants to complete their document production and amend their responses to interrogatory number 3 no later than August 3. Plaintiff requests that the court award him fees and costs incurred. So remember, he's dated it. So this is another thing that's so on the 20th of July, it's going to be really busy. You've got Paulson's motion to dismiss. You've got Chrisley's motion to dismiss counterclaim, and you've got motion to compel. It's going to be a big day. So remember, on the 20th of July. So that's their proposal, the 20th of July. Right. So now we've got this is the affidavit from Chrisley's lawyer. And so he's now going to outline all the attempts that he's made. So this is his declaration in support of plaintiff's motion to compel. He's laying out all the evidence. So we're going to read emails, we're going to see letters. All right. So this is Charlie Gocky. I'm apologizing, Mr. Gocky, if I pronounce your name wrong, because I'm Australian. That's my excuse. I come from the land down under. Right. So he's an attorney with Robbins Kaplan, representing plaintiff Michael Todd Chrisley. He makes this attest that as of the submission of this affidavit, defendants have produced 50 documents in response to plaintiff's request for production, along with 2 spreadsheets summarizing Ms. Paulson's responsive social media activity. I attest the plaintiff has attempted to confer in good faith with counsel for defendants to secure the relief requested. Specifically, plaintiff's counsel sent correspondence to counsel for defendants on March 7, 2022, March 15, 2022, requesting the defense counsel provide his availability to meet and confer and identifying the relevant issues. See Exhibits C and E. Counsel responded substantively to the March 7, 2022 correspondence without providing his availability and did not respond to the March 15th correspondence. See Exhibit D. Attached as Exhibit A is a true and correct copy of plaintiff's first set of interrogatories and requests for production. So then Exhibit B is the defendant's responses. Exhibit C is a true and copy letter of the March 7th letter to Graham Martin. D is the defendant's March 11 letter. E is a true and correct copy of the plaintiff's March 15 letter. Attached F is a January 11, 2022 letter. And G is a defendant's email. So we're now getting all the evidence. So they're proving that they have tried to meet with them. So this is, so plaintiff's first, so this is their production requests. So this is Exhibit A. So this is what they wanted. This is the plaintiff's requests are continuing in nature, requiring supplementary written responses. KJ can shut up. T quit with just old phone bills, providing calls with Lindsay and giving the number. Well, and I think that's all they want, Will. I think they want to know that there is this anonymous source, because if she can't cough up a source or an anonymous source, or she can't cough up a source, then she essentially proves that she's made it up. And when you make something up, it's really malice. So they've really got her in a corner. So there's one of two ways. She proves that she's got a source, or she admits that she's made it up and therefore admits that she was defamatory. So they want if any doc cannot be produced. So these are the instructions here. Here's the okay. So identify all individuals you believe may have knowledge, documents, or information relating to the allegations in the complaint. Identify all persons with whom you've had communication about the allegations in the complaint or any defences, claims, allegations you may intend to assert. Identify any member of Chris's Knows Best television production crew with whom you've communicated, including the nature, substance, and date of communication. For each individual statement at issue in this litigation that you contend is true, state your basis for asserting that that statement is true. Will says, I wouldn't be surprised if KJ got trolled by someone like that, pretending to be Lindsay and another. Well, that's fine. But the thing is, the onus is on her to prove that, Will. And if somebody has trolled her, that's in her interest. This is what I don't understand, that if you have been sucked in by something, then prove that you have been. You know, she's got herself in a very interesting position here. You know, so for each individual statement at issue, state what efforts you've made to verify its truth prior to publication. So she's got to prove that she verified that the person was from the Chrisley Knows Best. So to say that she didn't know who she was talking to isn't going to cut it. Identify all blogs, online forums, social media, networking websites, application services, software platforms, including video sharing, photograph sharing, blogging, messaging, peripheral message that you have had or which you've used someone else's account in the last 3 years. You've got to name the website, website address, account holder. For any account identified in response to interrogatory number 8 that you contend you transmitted or related plaintiffs. So identify any potential repository of electronically stored information, then requests for productions. So they want all the social media posts regarding Mr. Chrisley or communications, all notes, draft journals, and documents referring to or relating to Mr. Chrisley. Assumingly, anyone who is a journalist or anyone that works in media would know there would be notes somewhere. Most people, if they're researching something, would have some type of notes. I carry notebooks. I have a whole box of notebooks. So if you said this about this, it'll be a notebook. Or I would have a video, or I would have something. Yeah, but I generally I'm still old school. I still write old-fashioned notes. So I could hand over notebooks. All videos recorded by Katie Joy Postal relating or referring to Todd Chrisley, including videos that were not published. All documents you contend establish the truth. Documents to show engagement with social media. Any compensation, monetary that she's made. Documents to show without crystal ball's corporate structure. Organizational charts and operating agreements. Documents to show without crystal ball's compensation plan. And any documents that they rely on the defense. And that is actually normal. So what happens is you actually have to submit to the court your argument before you actually argue it orally. A lot of cases. So again, I can only refer to the Barilaro Google. They actually had to submit their arguments in writing on a certain date. And then they went and they presented those arguments. And that gives, and then, so one side presents their arguments and the other side gets to respond. And then the first party gets to respond to the response. And that's how it's set out. So this is, again, this is dated, this is their objections. So the responses, Lindsay Chrisley, an alleged So the witness, you've got 4 witnesses. Okay. And they don't know the contact information. Person with whom communicated. So the defendant number 2. Objection, calls for information provided by journalists privileged outlined. So they've objected to number 3, which was that. 4, Mr. Chrisley attempted to extort his daughter with a sex tape and nude photos. News items and police reports, conversations with Lindsay Chrisley, the victim of the threats and extortion. Defendant received statements from Lindsay Chrisley about these events as the victim of them. She stated particular details of the exchange with Mr. Chrisley and Chase Chrisley, the threats about potential for the release of the tape and photographs, the request by Mr. Chrisley that Lindsay give statements to federal investigators or prosecutors that would exonerate him, details of Mr. Chrisley's continued harassment of Lindsay. Doesn't tell me anything. A member of the Chrisley Knows Best contacted Paulson. The basis for this statement is that Paulson spoke with a member of the Chrisley Knows Best, and as a member of that conversation, Paulson has personal knowledge of that exchange. Chrisley's actions were driven by anger. Lindsay Chrisley would not. So again, she's talking about she's using news reports. See, and this is the bit that they want. She's trying to hide under journalistic privilege, but she's going to have to. She's going to have to prove to at least the court. She could act. I don't know whether she could, but she could apply to the court to let the court know who it is, so the court is satisfied without letting the other party know. And I don't know whether that extortion is a felony. The extortion is a felony. This statement has the benefit of being true. Makes it criminal to make a threat to expose a secret or deformity, publish a defamatory statement, or otherwise expose any person to disgrace or ridicule. Includes threat of non-consensual dissemination of private sexual images. What? But Todd Chrisley never wanted to extort her she says include threats of private sexual images. Does Chrisley have private sexual images of KJ? What on earth is she talking about? Chrisley threatened to destroy Paulson. Chrisley's confession podcasts 147, 148, 149, and generally in which the plaintiff issues threats and baseless statements of defendants in his own voice. So number 5, they didn't do. It is unclear what is meant by individual statement. Mr. Chrisley attempted to sort. Anyway, they've done that. As responding number 2, she spoke with a member. No additional. It was necessary because this is a true statement reflective of reality. Lindsay provided evidence for the extortion plot. Paulson spoke directly to Lindsay Chrisley. She reviewed Ms. Chrisley's public statements, including Dr. Phil interview, Ms. Chrisley's Twitter and Instagram posts, and content already published and verified by other news media outlets. So, in social media, I'll just do that. So she's got a smartphone, home computer, and Google Drive. So this is their responses. They're vague. All notes, drafts, journals, and other documents. Objection. This requests us for documents not related to the claims or defences of the parties related to plaintiff's complaint. To the extent defendants have documents responsive to this request are within the scope of the rules. So ongoing will be produced according to defendants' obligations under the rules. Yeah. So they've objection. This request calls for production of documents outside the scope of litigation. They object to showing the compensation. They object to the structure of the business. I mean, I don't know. I mean, there would be some argument to say that he would need to know whether or not Chrisley would need to know whether or not she had any money. So this is an audit trail. For that. So it was signed, it was viewed, it was sent, viewed, and signed. Yeah. All right, so this is Exhibit C. So this is to Graham Cracker. Graham, we write regarding Catherine Paulson's deficient interrogatory responses and her invocation of journalists' privilege to avoid providing information relevant to this litigation. That privilege does not apply, and Ms. Paulson must supplement her discovery responses. Plaintiff's interrogatory number 3 requested that Ms. Paulson identify any member of the Chrisley Knows Best television production crew with whom she has communicated, including the nature, substance, and date of communication. Ms. Paulson responded only objection calls for information protected by the journalist's privilege outlined in Minnesota statute and Cervantes versus Times. Subject to that objection, defendants never received the name of any person with whom they were in contact. Ms. Paulson thus refused to provide any information concerning the nature, substance, and date of communication. Any information she may possess concerning the identity of the individual at issue beyond his name or her name, or any efforts undertook to confirm the individual's claims. The journalist's privilege Ms. Paulson invokes does not apply. The Minnesota Free Flow of Information Act includes an exception that applies in defamation cases. See Minnesota Statute 525.025. It looks like Chrisley's lawyers schooling Paulson's on the law. The defamation exception applies when the plaintiff can demonstrate the identity of the source will lead to evidence having any tendency to prove or disprove that the defendant spoke with knowledge that the statements were not false or with reckless disregard as to whether the statements were false or not, in Weinberger versus Maplewood Review. The plaintiff need not prove that the declarant indeed spoke with actual malice before exception can be applied, but only need to establish that the identity of the source will lead to relevant evidence on the actual malice. The information sought through interrogatory number 3 bears squarely on the issue of whether Ms. Paulson acted with actual malice, in stating that the interview with an anonymous Chrisley Know Best crew member corroborated Lindsay Chrisley's allegations. In particular, a statement may have been made with actual malice if it is fabricated by the defendant, is a product of his imagination, is based wholly on the unverified anonymous telephone call, or if the publisher's allegations are so inherently improbable that only a reckless man would put them in circulation. I think you got your answer there. In Chalifus versus Peterson. Whether Ms. Paulson fabricated this interview or, as she apparently claims, reported based wholly on an unverified anonymous phone call, is crucial evidence of whether Ms. Paulson knew her statements to be false or acted recklessly in making them. The exception requires probable cause to believe that the source has information clearly relevant to the issue of defamation and that the information cannot be obtained by any alternate means. Terry says, don't you need to have reporters to claim that title? Otherwise, she's a gossip reporter who never says, in my opinion, or supposedly. I don't know about that one, Terry. I don't know what the rules are. The exception also requires probable cause to believe that the source has information clearly relevant to the issue of defamation and that the information cannot be obtained by any alternate means. First, there is probable cause to believe that there is no confidential source or that the source was not who they claim to be and that Ms. Paulson simply parroted the false allegations of the anonymous caller, both of which are clearly relevant to actual malice. When the identity of the speaker is hidden under the cloak of anonymity, it is self-evident that the identity of the speaker will lead to relevant evidence on the issue of actual malice, and this information can only be obtained through Ms. Paulson. In sum, the Free Flow of Information Act does not excuse Paulson's failure to answer interrogatory number 3. Ms. Paulson is also incorrect that she is protected from disclosure by Cervantes and Time. If they don't produce, they can't use them later, but you don't know what they're pitching to the court, the scam. Well, that's right. And one of the things the court needs to know that everything's out in the open, you know. As I said, you actually, particularly in Australia, you actually have to submit all your arguments into the court beforehand. So, and that also helps where if the judge has to make a decision on the day, they can, sometimes they actually will read them and they already know the questions that they're going to ask of the counsel to try and get to the bottom of it. So Ms. Paulson is also incorrect that she's protected from disclosure from Cervantes versus. In Cervantes, the Eighth Court articulated a test for determining when a defendant journalist may invoke a constitutional privilege to avoid disclosure of confidential sources in a libel suit. But the Minnesota Supreme Court has not recognized the First Amendment journalistic privilege and has never adopted the standards set forth in Cervantes. In unprofessional conduct. In fact, the Minnesota Supreme Court has noted long-standing disagreement with Cervantes' reasoning. Rather than rely on judicial adoption of the Cervantes standard, the Minnesota legislature enacted the Free Flow of Information Act, which provides the sole source of protection for journalists in Minnesota courts seeking to shield their sources. And shouldn't the Minnesota adopt the Cervantes standard, Mr. Chrisley has made a concrete demonstration that the identity of Poston's news source will lead to persuasive evidence on the issue of malice. As discussed above, this information bears on whether Ms. Poston fabricated a source or parroted the unverified allegations of an anonymous source. In sum, Ms. Poston cannot excuse her deficient response to interrogatory 3. She must supplement her discovery responses, or we will file a motion to compel this information and seek our fees for doing so. Please reply no later than March 11, 2022, confirming Ms. Poston will supplement. So that was on March the 7th. Okay? So then they got this one. This is from Graham Cracker. Dear Marcus, I'm in receipt of your letter dated March the 7th regarding Ms. Poston's response to your client interrogatory number 3. For the reasons below, we disagree with your assessment of Ms. Poston's obligations to provide the requested information, and additionally disagree that we have not provided a forthcoming response as required by the rules. The substance of the information requested by Mr. Chrisley's interrogatory number 3 involves Ms. Poston's mere reporting of a statement she received from an anonymous source stating, I believe her, which refers to by your client's own allegations. In his complaint, Lindsay Chrisley's public and nationally broadcast statements about her own personal experiences with Mr. Chrisley. The statement at issue, I believe her, is an expression of opinion, not subject to claims of truth or falsehoods necessary to support a defamation claim. Furthermore, Ms. Poston's reporting on her receipt of the opinion statement is similarly insufficient to support a defamation claim. Ms. Poston reported on another party's opinion, which has no bearing on whether Lindsay Chrisley's statement is true. The only way Ms. Poston's statements regarding the matter addressed in interrogatory 3 could be potentially defamatory and are subject to an analysis regarding whether they were uttered with actual malice would be if Ms. Poston's reporting on Lindsay Chrisley was fabricated. But it was clearly not fabricated, given that Ms. Chrisley's statement were uttered by her on a camera, broadcast nationally, and remain available for instant viewing at any time on Dr. Phil's website. In supporting your contention that Ms. Poston's response is sufficient, we cite you to both Minnesota statute, which doesn't exist, and Weinberger v. Moferback Review. Neither of these legal bases provide support sufficient for compelling production of the requested information, because they demand production of information for assessing the existence of actual malice, which is only an issue if there exists an actual defamation claim. But the truth is an absolute defense to defamation in Stevens and Ridwin, and everything alleged by Mr. Chrisley in his complaint regards Ms. Poston's reporting on verifiable statements made by Lindsay Chrisley. Ms. Poston reported on statements made publicly by Ms. Chrisley, and if Mr. Chrisley disputes the veracity and potential harm to himself of Ms. Chrisley's statements, the proper defamation claim is against Ms. Chrisley, not Ms. Poston. Weinberger is fundamentally inapplicable to the situation in this case because Weinberger, the courts had already determined that defamatory statements existed and that the only remaining issue was to determine the existence of actual malice necessary to maintain the defamation claim against a public official. So just on a side note, so what we've got here is we've got the letters are both using the same case but are arguing different points, and this is where a judge will come in, and the judge then may actually have their own interpretation of that case and will determine which argument is actually correct. This is where, in some cases, law is a little bit subjective because everybody can read, and I've seen this. We all read a case, and we were asked about it, and we all had different interpretations of the case. We all had different opinions of how we thought it should play out, and so this is where it can be subjective. So they're using a different argument. They say, no, this doesn't support your claim because of X, Y, Z. where Chrisley's lawyers said these cases support our claim because of XYZ. So this is where it really gets fun, and this is where arguments, particularly when it gets to the court, this is where it gets fun, and this is where the arguments and will all play out when they start filing their arguments, and we get closer to a court date, and we start seeing this because they have to then convince the judge that their interpretation or their application of it is correct. This is the fun bit, and again, you have to back it up. So the district court has determined that the statements are false or defamatory, that based on the depositions and affidavits submitted by the plaintiff, material issues of fact exist as to whether these statements were actual and malice. No such agreement exists in this case. On the contrary, the court here is yet to opine on the issue of whether the truth of Miss Paulson's reporting is a bar to Mr. Chrisley's defamation claim, an issue which will similarly need to be decided in any motion to compel discovery of your client's files, despite the fact that it will also need to be decided that Miss Paulson's pending motion to dismiss. So they've sort of said here that the court needs to decide, because there is no determination that there is even a cognizable prima facie basis for Mr. Chrisley's defamation claims. Investigations as to whether actual malice exists is premature, and continued demand for privileged information on those grounds is at best wasteful to the party's resources, and at worst an attempt to harass Miss Paulson and or the speaker of the statement at issue. Oh, she's going to now accuse the lawyers of harassing her. Okay. Furthermore, Mr. Chrisley has not met the requirement of defamation exception in the Minnesota Free Flow of Information Act. The FFIA prohibits disclosure of witness identities in all but a few very narrow exceptions. The defamation exception to which you refer in your letter requires meeting two conditions, neither of which you have met by Mr. Chrisley. A, that there is probable cause to believe that the source has information clearly relevant to the issue of defamation, and B, that the information cannot be obtained by any alternate means or remedy less destructive of First Amendment rights. I've already addressed the issue of probable cause because there is no reason to believe that the cause of action for defamation actually exists, given that the complained of statements are true, and there is no probable cause that an investigation into actual malice will bear fruit likely to impact Mr. Chrisley's defamation claim. And Mr. Chrisley has not provided any information describing the alternate means he has used to try and procure the requested information. In short, Mr. Chrisley has not met the requirements of the disclosure exceptions provided by the FFIA, and the basis for requiring the requested disclosure outlined in Weinberger are inapplicable, given that there is no basis, either prima facie or adjudicated, for showing the success of Mr. Chrisley's courses of action in any way on the existence of actual malice. Because the existence of actual malice is inconsequential, there is no basis for the disclosure you seek. I see generally dissenting discussion weighing relevant factors in ordering disclosure of sources. I find two factors weigh heavily against compelling the reporter to disclose these sources. Weinberger has made no showing that the information is material, nor that the information is necessarily or critical to his case. In other words, if he cannot approve defamation anyway, information regarding actual malice is moot. There is no defamation without falsity. Unless Mr. Chrisley can provide evidence that the statements to which he is concerned, those made by Lindsay Chrisley in police reports and recorded interviews, are actually fabricated by Miss Paulson, there is no basis for this ongoing suit, no basis for disclosure of information. You have requested bringing additional motions on this matter will be a waste of parties' resources and waste of time of the court that is already stretched too thin. While we continue to work on the production of documents you have requested, we will not be supplementing our response to interrogatory number 3. Please let me know if you have any questions. I hope you are otherwise well. Have a good day and excellent weekend. Signed, Graham Cracker. It's definitely going to be very interesting. This is going to be a great one. All right, so this is now on the 15th of March. Graham, thank you for your response. As an initial matter, you contend that the statement, I believe her, is merely an expression of opinion. But the defamatory statement at issue is not Miss Paulson saying, I believe her. The defamatory statement is Miss Paulson's false claim that a member of the Chrisley crew who has intimate knowledge of Mr. Chrisley and his family said, I believe her. With respect to Lindsay Chrisley's allegations about her father, and that this individual provided supporting details. If there is no such individual, or if the individual is not a member of Chrisley's No Best crew, Ms. Paulson's claim that an individual with non-public knowledge supports Lindsay Chrisley's allegations is false and defamatory. Moreover, there is no wholesale defamation exception for anything that might be labelled opinion, as if a speaker says, I'm in the opinion John Jones is a liar, he implies a knowledge of facts, which leads to the conclusion that Jones told an untruth in Malkovich versus Lowe. Such is the case here. Miss Paulson's claim that an individual who has intimate knowledge of Chrisley's, Mr. Chrisley and his family, supports Miss Chrisley's allegations not only falsity points to the existence of such an individual, but falsely implies that the individual's knowledge of relevant facts. You take the position that Miss Paulson's statements at issue in this case are not defamatory, because they truthfully relay allegations against Mr. Chrisley originally made by his daughter. Setting aside Miss Paulson's own unique embellishments on those allegations, not at least of which is her claim that an unnamed Chrisley Knows Best crew member supports Miss Chrisley's story. This is incorrect as a matter of law. Under common law republication rule, one who repeats otherwise republishes defamatory matter is subject to liability as if he had originally published it. Explaining that the republication rule provides that a speaker who knows or should know that a statement is false and defamatory repeats it nonetheless is equally liable for the defamation as the original speaker. Indeed, as particularly relevant here, parroting allegations made in an unverified anonymous telephone call is a textbook example of a defamation statement made with actual malice. The fact is, it is verifiable. Miss Chrisley made some of the allegations at issue in the first instance in no way relieves Miss Paulson from the liability for repeating them and variations on them, and is beyond serious dispute that the allegations here are defamatory. You also argue again that discovery is wasteful until the district court rules on your motion to dismiss. As we've explained before, we expect that the motion will not succeed. And regardless, there is no stay of discovery in this case. Your belief that the court may ultimately see the merits your way does not impact Miss Paulson's current discovery obligations. Actually, that's a good point. There's been no stay that I can see of discovery. So they needed to really have applied to have discovery stayed. But anyway, they didn't. Finally, you contend Mr. Chrisley must prove the information describing the alternative means he is used to try and procure the information requested, but no alternate means of obtaining the information available. Miss Paulson claims to have had a private telephone call with an anonymous individual. Miss Paulson is the only identifiable person with the knowledge of that phone call, and the individual who allegedly placed it. Indeed, if, as we suspect, Miss Paulson's claim regarding the anonymous Chrisley Knows Best crew member are false, there is no other existing source of information besides the person who fabricated the interview. Please let us know when you're free this week or early next to confer, as we intend to move to compel. Please also advise the status of Miss Paulson's outstanding document production. We understand from your letter that Miss Paulson's document production is in process, but it has now been months, so we've not seen any documents beyond Miss Paulson's social media posts. If other responsive documents are not forthcoming within a reasonable time, we reserve the right to address our motion to compel. So this is on March the 11th. Good afternoon. Please see attached Miss Paulson's response to your letter dated March. I hope all is well. All my best. Cracker Martin, James Cracker. Then this is, good morning, Graham. Please see attached letter regarding Miss Paulson's deficient discovery response. Please advise by the end of the week either of your intent to supplement the response or your availability to confer. So again, they're stating that they've made 2 attempts. Hello, short order. Exhibit F. This again is on January the 11th, 2022. Good morning. Both parties have provided their initial disclosures timely, and we're still waiting time for a hearing on my client's motion to dismiss. I've called the court multiple times to get a hearing on the calendar. They're not receiving calls currently, only voicemail. It seems premature to invest huge amounts of resources in a case that is awaiting a hearing on the motion to dismiss. We will gladly provide discovery responses when they are justified based on necessity to address the actual controversy. But as it stands, Ms. Paulson believes that there is no cognizable basis for the suit. Of course, because Ms. Paulson knows. Paulson knows best, right? This bothers me. Ms. Paulson believes that there is no basis for the suit, where everyone's resources to continue to engage in substantial discovery at this point. You will likely disagree with my assertion. If you're feeling inclined to bring a motion to compel a discovery, please let me know before you take that step. It's interesting that he says Miss Paulson believes that there's no basis to sue. What about you, Graham Cracker? Graham, we're writing because we did not receive responses to our document requests and interrogatories that were due yesterday. Please confirm and we'll receive the responses today. If you need to request an extension of time to respond, we are willing to extend that courtesy. Remember, they just have to prove that they have done everything in their power to get to show that they've tried to do this without asking for the motion to compel. Please find spreadsheet labeled Twitter posts. My client's responsive to client's discovery. We provide this to supplement the defendant's earlier production. Well, thank you for your patience. And that was it. So that is the latest filings. It's going to come down to, essentially, it's going to come down to the judge having, the judge is going to have to work out which side is correct on their interpretation of the law. So it's definitely very interesting. What are your thoughts on this? Tell me, what are you thinking? Okay. After this, very shortly, because I'm nearly losing my voice, so I'm going to have to go. So I need to touch on the Barilaro, our mate Barilaro. Chris Minns, the opposition leader in the New South Wales Parliament, he and the upper house have ordered an investigation into the appointment of Barilaro. Now, he tweeted this. He needs to file the client. Yeah, look, this is what Chris Minns said, okay? He's the opposition leader. Break-in. The head of Investment New South Wales just confirmed the cabinet gave a direction to withdraw the offer for the new NYC role to the candidate it was offered to, only for John Barilaro to take it up, despite Dominic Perrottet, who's the Premier, claiming that this was independent. Extraordinary. The head of Investment New South Wales has confirmed that it was given a direction. So the Sydney Morning Herald where was it? Here. Feared ministers messing with due process of trade posts. So now all the talking about emails and everything coming out. An incoming secretary of the Department of Premier and Cabinet feared ministers would meddle with the appointment of trade commissioners and urged, really? Woohoo! I'll need to look at that. Internal mails from July last year obtained by the Herald suggest incoming Secretary Jim Betts wanted recruitment reports for the lucrative roles finalised before they were sent to ministers, including then Deputy Premier John Barilaro. The appointment process behind the trade roles is under fierce scrutiny. So the July correspondence between Investment New South Wales boss... Go find Just Doom. Are you still there, Doom? Sorry, Doom. An upper house inquiry into Barilaro's appointment will hold its first hearing. So in an email on July 25, Brown wrote, Jim B strongly recommends that recruitment reports fully signed by each panel member before this brief is sent up to ministers in anticipation of the messing with the process. Betts was one of the 3 bureaucrats to interview for the US posting, along with Brown and former Tasmanian Liberal Senator Warwick Smith. Another email, Brown's chief of staff said she would prepare drafts of the interview panel reports for then Treasurer Dominic Perrottet, then Deputy Premier Barilaro, then Jobs and Investment Minister's heirs, and 2 senior public servants. The following week, Investment New South Wales wrote to Betts' office, insisting that they send a signed copy. At the moment, Terry, he's not. They're investigating how he got the job. Leader of the opposition in the upper house, Penny Sharp, said the public was right to be concerned with the revelations contained in the internal emails. These documents show that New South Wales' most senior public servants have been forced to try and protect recruitment processes from ministerial interference. Perrottet on Tuesday insisted that the Trade Commissioner roles were not statutory roles independent of Cabinet. However, he said Barilaro had told him of his intention to apply for the US role in a social setting sometime after the Deputy Premier had left Parliament. I think in the social setting, he may have said he was applying for the position, which is an independent process. I speak to people socially all the time, and there is always interested people saying, I'm interested in this and interested in that. I was advised by Minister Ayres at some date that he had applied for the role, but that was an independent process and that we would not be intervening. So the Premier is actually still maintaining that there was no interference, and yet we've got here that he doesn't seem to have he doesn't have the same privilege anymore. Let me see that CV. Extraordinary. Amy Brown just gave evidence that Jenny West was preferred candidate for the New York role, was given verbal approval only for John Barilaro as minister to instruct that Brown had to retract the offer to Miss West, unwind all contracts yet to commence. It was Barilaro that stopped it. So the offer to West was retracted because there was going to be a change in policy where ministers would appoint the person, but it didn't happen. And the public service appointed John Barilaro instead. Then West is entitled to that role. She was appointed the role. So the woman that got the role was actually offered the role verbally. She had met all the criteria. I mean, John Barilaro's got a certificate 4, I think. Right? She was the correct candidate. She'd been offered the role. And then he said, no, we're going to make it a ministerial role. And then there's some interference in there. And then suddenly the role becomes available and it's appointed by Cabinet. So according to John Perrottet, an independent recruitment process recommended based on the interviews the former Deputy Premier be appointed to the role. But when it first recommended Jenny West to get the role, the offer was rescinded, struggling to see the independence here. Barilaro wanted to know mechanisms for appointing trade commissioners. He created the roles, yet asked for this information from the lead bureaucrat. Does this display a lack of attention to detail? The whole situation stinks, and no way Premier wasn't in on it. It's fun. It's fun to go to the ICAC. It's fun to go to the ICAC. I see. It's fun to go to the I see. Perrottet in deep doo-doo. Seems about time all ministerial appointments are removed and that process never be permitted. Too often corruption for it to be in a reasonable time. What's the problem? Extreme corruption is how New South Wales government works, particularly if they're a Liberal Party and no one can do a thing about them. The system allows it. It's fun to go to the I see. It's fun to go to the I see. That's where corrupt go. They get found out. And then we love to show them the door. It's fun to go to the I see. It's fun to go to the I see. I've lost the plot. COVID delirium, hey? Well, short order cook. Look, I don't like to play the gender card at all, but she was also, I believe, the only female that was appointed in those commissioner roles. And we know how much everybody's about gender equality at this point in time. And equality. And so for a very smart, well-educated woman to not be given the job over Barilaro is quite the gold standard. Gold standard. That's what New South Wales is. I say gold standard. They've lost a few premiers. Gold standard. It's fun to go to the ICAC. It's fun to go to the ICAC. Anyway, if you like that, just hit like. Or maybe in my time I might just write a whole song to it. Thank you to whoever wrote that on Twitter. That was great. So I'm gonna love you all and leave you all. So I might see. Was it what did 7 News Sydney Twitter has today's hearing? And I might put a link in there if you want to watch it. Let me find it, and if I can find it for you, I'll post it, and you can watch it all play out. 7 News Sydney, because I'm very interested myself in how it's all doing it and how it's all happening. Oh, here we go. Oh, it's called John Barilaro Inquiry.
Just ask you that before.
Here it is. If you'd like to watch it, I'm going to watch it now. Well, I mean, she could use gender, definitely. So if you want to follow this and see how it's all done, feel free. There it is. There's 500.
My senior cluster minister, Minister Ayres, the Minister for Enterprise, Investment and Trade, more in terms of checking in and support to make sure I was prepared for today, but not as to the content.
Oh, really? They US don't want him?
Ministerial officers? No. Not Premier's office? Not Premier's office. No. And have you received any texts or emails from any of the any other ministers or?
So that's what it is. So if you're interested in watching, that's the link. I'll catch you all later, and I know what I'm doing now.
Mr. Barilaro has signed a contract to become the Senior Trade and Investment Commissioner to go to New York. Is that correct? That is correct. Yes. And when did he sign that contract? The contract commenced on the 20th of June. It was approved by me on the 16th of June. So between the 16th of June and the 20th of June is the most accurate I can say. And it was